Welcome to today's webinar, Disciplinary Procedures, an Introduction to the Investigation Process. My name is Kieran and I am your organiser for today. I'll be supporting today's presenter Vicky by helping behind the scenes, talking you through some of the questions we're receiving and carrying out a couple of polls.
So hello everyone, my name is Vicky and I'm your presenter for today's webinar, Disciplinary Procedures, an Introduction to the Investigation Process. So before we get started, just a little bit about who Acas are and what we do. We provide employees and employers with free, impartial advice on workplace rights, rules and good practice. We also offer training and we'll let you know about relevant training courses for today's topic a little later, including how to book. We help resolve disputes. Our online advice is updated regularly, where you can find the latest information on discipline and grievance, along with wider workplace advice for employers and employees. Our website has a number of free template letters, forms and policies for employers, HR managers and employees, which are free to download and use. So now let's look at what our webinar will focus on today. So just to briefly run through the agenda, we will be covering when and why should you carry out an investigation, how to prepare for a disciplinary investigation, how to conduct the investigation, actions to take after the disciplinary investigation, and finally, we will look at further support available. Let's start by looking at what an investigation is and when it might be necessary to carry one out. Workplace investigation is a formal process used by employers to look into potential problems at work, such as allegations of bullying or harassment, a disciplinary issue or misconduct, or when an employee raises a formal grievance. It's a key step in making sure issues are handled fairly. The main goal of an investigation is to find out what really happened. This involves gathering facts and evidence, assessing the situation, and deciding whether there is a case to answer. A good investigation helps an employer make informed decisions about what to do next, whether that's taking formal disciplinary action, resolving things informally, or dropping the matter completely. It's important that the process is fair, unbiased, and consistent with company policies. If an employer skips or mishandles an investigation, it can lead to unfair outcomes, cause damage to trust and morale in the workplace, and result in employment tribunal claims. Before launching an investigation, employers should consider if there are workplace policies that require an investigation in this situation. Does the issue require further action? And would an informal check of facts, such as a preliminary investigation, help? If the decision is made to investigate, it should begin as soon as possible. Delays can lead to faded memories or perceptions of unfairness. That said, employers should still look for a chance to resolve the issue informally at any stage if it becomes possible. The Acas Code of Practice on Discipline and Grievance Procedures sets out the minimum an employer should follow when handling these issues in the workplace. It says that it is important to carry out necessary investigations of potential disciplinary matters without unreasonable delay to establish the facts of the case. Sometimes this will require an investigatory meeting with the employee. In other cases, the investigatory stage will be the collection of evidence by the employer for use at any disciplinary hearing. If possible, different people should handle the investigation, the disciplinary hearing, and the appeal meeting in misconduct case. An investigatory meeting should not lead to disciplinary action on its own. Employees don't have a legal right to be accompanied at an investigatory meeting, but it is good practice to allow it. Although today we are focusing on investigations and disciplinary procedures, it is important to remember that employees do have a right to be accompanied at any meeting in a grievance procedure. If an employee is suspended with pay, it should be for a short time, reviewed regularly, and clearly explained that it's not a punishment. Employers should carefully consider whether the suspension is necessary, and if so, it should be on full pay. The next part of the webinar will focus on the preparations leading up to a disciplinary investigation. So let's start by looking at how to choose a person to carry out an investigation. So selecting the right person to lead an investigation is an important step in handling disciplinary matters fairly and objectively. The investigator's role is to gather all relevant facts, both for and against the allegations, and determine whether there is a case to answer. They do not decide guilt or issue outcomes. An investigation that is poorly handled or biased can lead to unfair decisions, damage employee trust, and even result in legal claims. A fair and objective investigator helps ensure that any decisions made later are based on clear, reliable evidence. The ideal investigator is someone who is not personally involved in the matter, has no conflict of interest, can remain neutral and objective, understands the organisation's policies and procedures, and is trained in investigations or experienced in handling sensitive issues. If possible, an investigator should be a manager from another team, an HR officer, or a senior staff member with no stake in the outcome. In more serious or complex cases, such as those involving allegations against senior staff, employers may choose to appoint an external consultant to ensure impartiality. So ideally, different people should be responsible for each stage of the investigation process in a disciplinary case, such as the investigator to gather facts and evidence, a decision maker to review the investigation and conduct the disciplinary hearing, and an appeal officer to handle potential appeals. They should preferably be senior to the decision maker and have an authority to decide on the outcome. This separation helps maintain impartiality and fairness throughout the procedure. So let's now look at how to make an investigation plan. So one of the first steps of conducting an investigation should involve creating an investigation plan. An investigation plan acts as a roadmap for the entire process. It defines what needs to be investigated, who is involved, what evidence must be gathered, and how long the process is expected to take. It also ensures that the investigation stays focused and consistent. So let's look at what the plan should contain in more detail. So the plan should begin with a clear explanation of what is being investigated. This includes a brief summary of the complaint or incident, who was involved, and when and where it took place. This section, often referred to as the terms of reference, sets the scope of the investigation. It should also specify who will be carrying out the investigation. This person should not be involved in the issue in any way and should have the appropriate skills and training. The plan should record who the investigator is and whether they are expected to make recommendations at the end. Another thing to include in the plan are target dates for key steps such as conducting interviews, collecting evidence, and writing the final report. A realistic timeline helps keep the investigation on track and avoid unnecessary delays. The plan should reference policies and procedures to review and follow by the investigator. These might include the organisation's bullying and harassment policy, grievance and disciplinary procedures, the Code of Conduct, or equality and inclusion guidelines. One of the most critical parts of the investigation plan is identifying what facts needs to be established. These might include what happened, who witnessed it, whether any rules or laws were broken, and how the issue affected individuals or the workplace. Setting out clear objectives from the start helps keep the investigation focused and ensures that the final report answers the key questions. The plan should outline what evidence is needed and how it will be gathered. Depending on the nature of the case, this could include emails, instant messages, CCTV footage, attendance records, or expert reports. The investigator must ensure data protection regulations are followed when handling personal or sensitive information. The plan should include a list of people likely to be interviewed. Typically, if the investigation is because someone made a complaint, they should be interviewed first, followed by the person accused, and then any witnesses. Subject matter experts may also be included if technical details need clarification. Interviews should be arranged in logical order, and the plan should allow flexibility to add others if new names emerge during the investigation. No matter how well planned an investigation is, unexpected developments can occur. A good plan should be flexible enough to adapt. New evidence may arise, or additional witnesses may need to be interviewed. The investigator should be ready to update the plan as the situation evolves, documenting any changes along the way. Investigation plan templates are available online on the Acas website. When a workplace investigation is launched, whether for a disciplinary issue or a grievance, it is important to keep those involved informed. As soon as the employer decides to begin an investigation, they should inform the employee concerned unless there is a genuine risk that the person might tamper with evidence, influence potential witnesses, or obstruct the investigation in any way. In such exceptional cases, it's reasonable to delay the notification until the risk has been reduced. When notifying an employee that they're under investigation, it's best to do so in writing. The letter or message should include why the investigation is taking place, for example, a complaint or a misconduct allegation, who will be carrying it out, what the process will involve, such as reviewing documents, speaking to witnesses, conducting interviews, an estimated timeline, including when they can expect an update. What happens next, for example, being invited to an investigation meeting. A reminder that the process is confidential, however, and employees should be allowed to discuss the investigation with a trade union or workplace representative where they have one. Contact details for someone they can speak to with questions. This is often HR or the investigator. Providing this information clearly helps reduce uncertainty and supports the employee's right to a fair process. When an employee is asked to attend an investigation meeting, either as the subject of the investigation or as a witness, they should be given advance notice in writing. The invitation should include the time and place of the meeting, the name of the investigator, and the reason for the meeting. It's crucial to make clear that the meeting is part of the investigation and not a disciplinary hearing. While these meetings are formal, they are intended to gather facts, not assign blame. Employees should be asked to keep the matter confidential and, where appropriate, be informed whether they're allowed to be accompanied by a colleague or a union representative. Providing this information in a respectful and professional tone helps maintain a fair and constructive environment, even when the subject matter is difficult. The investigator should also keep line managers informed, especially if the meetings may affect day-to-day operations. Planning interviews around busy times or service needs can minimise disruption. So, for example, if a customer support team is being investigated, meetings should be scheduled outside their peak hours to avoid service issues. Employers can make use of the Acas templates to draft letters for informing an employee that they are subject to an investigation and inviting someone to attend an investigation meeting. These templates are available on the Acas website. When carrying out an investigation, employers should consider if they need to remove the employee from their normal duties during the process. Employers should begin by gathering basic information. For example, what happened, who was involved, and how serious the issue might be. This early fact-finding helps determine whether any action, including removal, is necessary. Automatically suspending or relocating an employee without justification can damage morale, trust, and potentially breach the contractual terms. It is important to recognise that many workplace investigations can be carried out without removing an employee from their normal working environment. For example, if there's no danger to people, no risk of evidence being tampered with, and working relationships remain stable, there may be no need to suspend or move the employee. If some action is needed, a temporary transfer can be a more balanced solution. Instead of suspending someone, an employer might move them to a different department, shift, or role for a short time. So I'm going to hand you over to Kieran to illustrate this now with a case study. Over to you, Kieran.
Thanks, Vicky. So, meet Jake and Anna. Jake and Anna had a heated argument at work and are no longer able to work effectively together. Their employer must decide how to manage the situation without escalating the tensions. Rather than suspending either employee, which could cause unnecessary stress, the employer implements a temporary measure by transferring Jake to a different team with his agreement. This move allows operations to continue smoothly and helps reduce direct conflict between the employees. The transfer was clearly explained to both parties as a neutral, temporary step to support the investigation and not as a disciplinary action. Care was taken to ensure the new role matched Jake's original position in terms of responsibility and status, preventing any perception of demotion. This approach demonstrated a balanced and fair response, enabling the investigation to proceed without the negative implications often associated with formal suspension. I'll hand you back to Vicky. Over to you.
Thanks, Kieran. So, in more serious cases, suspension with pay may be necessary. However, suspension should never be used automatically or as a disciplinary action. It's a temporary measure to protect the investigation, the people involved, and the organisation. Before deciding to suspend an employee, employers should consider other solutions. Could they work from home? Could their duties be adjusted? Could the individuals involved be separated in another way? Alternatives like these are often less disruptive and can still protect the integrity of the investigation. If two people are involved in a conflict, the employer should carefully assess who, if anyone, should be moved. Generally, it's best not to move the person who raised the complaint unless they have requested it. Whether an employer decides to relocate or suspend someone, their mental health and well-being should be a priority. Employers should communicate clearly, offer support, and ensure the person understands the action taken is temporary and not a judgment on their conduct. So the next section of our webinar will focus on carrying out the investigation. So let's start by looking at a common query asked on the Acas helpline. How long should an investigation take? So there's no one-size-fits-all answer to how long a workplace investigation should take. It depends on the complexity of the case, how many people are involved, and whether any new information comes to light. If the organisation has a policy with a suggested timeline, then it should be followed. If there is no set time frame, the person handling the investigation should give an estimated completion date at the start and update it if things change. While it's important to complete investigations as quickly as possible, they also need to be fair and thorough. Rushing the process can lead to mistakes and unfair outcomes, which could cause further problems or even lead to legal action. Simple cases might take just a day or two to complete, while more complex cases involving several witnesses or new evidence may take a few weeks or more. Sometimes new issues come up during an investigation. When that happens, the investigator may need to adjust the scope or even start a new investigation. If delays happen, they should be explained to everyone involved and recorded in the investigation report. Employees should always be kept up to date. If the investigation is going to take longer than expected, employers should let them know why and when it's likely to be finished. In an investigation, the role of the investigator is to establish the facts. This means they must consider all available evidence, not just what supports the allegation, but also anything that might contradict it. Types of physical evidence that can be helpful with an investigation can include emails, paperwork, receipts, computer or phone records, CCTV recordings, attendance records, or vehicle trackers. Any evidence must be collected lawfully and without breaching employees' contracts. The investigator should document what the physical evidence is, how it was obtained, and what it shows. This helps ensure clarity when referring to it later in the investigation. Any physical evidence should be securely stored for future reference. Searching an employee or their possessions should only happen in exceptional circumstance where there is a clear and a legitimate reason. Even when a contract allows such searches, consent is usually still required. If a desk or cupboard needs to be searched, the employee should be invited to be present. If this isn't possible, a manager should witness the search. If an employee refused to be searched, despite a contract allowing it, this could be seen as uncooperative behaviour. However, investigators should not assume guilt. There may be a valid personal reason for refusing, and these should be explored respectfully. In situations where a criminal offence is suspected, the employer may contact the police, who have broader powers to carry out searches. All search requests, consents, and refusals should be clearly recorded. So now let's take a look at the role of a witness during an investigation. So witnesses can give important information that can help an investigator decide whether there is a case to answer. A witness statement is typically a signed copy of the notes from the investigation meeting. After the meeting, the interviewee should be given their statement as soon as possible so they can check it while the details are still fresh. Once reviewed, they should sign it to confirm its accuracy. If any changes are requested, the interviewee should sign next to the amendments. If the investigator believes the changes contradict what was originally said, both versions should be included in the final report. If the interviewee refuses to sign the statement, the investigator should explore the reason. If the issue can't be resolved, the statement can still be included in the report along with a note explaining the refusal. In some cases, an investigator may decide that a witness statement can be provided in writing without a meeting. This could also apply when the witness is not an employee, the facts are straightforward, or the witness is unable to attend due to illness. The investigator should set a clear deadline and request that the witness includes their name and, if relevant, job title, the date, time, and place of any relevant incidents, what they saw, heard, or know, and how they knew it, the date and time the statement was made, and their signature. However, written-only statements have limited value if the witness's account is unclear or requires further questioning. It is not uncommon for colleagues of those who are being investigated to be reluctant to give evidence, and some may only agree to do so if the employer agrees that their statement can be anonymised. The reasons for wanting to remain anonymous can vary from fear of reprisals to simply not wanting to become involved in a disciplinary matter. So let's pause the presentation again to look at a case study, and Kieran will go through this one with you. Over to you.
Thanks again, Vicky. Andrew is being investigated following the theft of goods from the shop he works in. The CCTV evidence is inconclusive. The list of potential witnesses includes 3 colleagues who worked the same shift on the day in question, and a customer who notified the store manager that Andrew's actions were suspicious. The customer does not want to attend a meeting to provide a witness statement, believing they've already given enough information, but they agree to give a statement by telephone and then review, sign and date it. Jenny was working with Andrew that day, but tells the investigator she didn't see anything. Martin worked with Andrew that day and has agreed to make a statement about what he saw. Rory was also working with Andrew on the day of the alleged incident, but tells the investigator they are only willing to give a statement if anonymity can be guaranteed. So in this case, what should the investigator do? Well, now we'll meet Rory. The investigator asks Rory why they want their statement to be confidential, and Rory reveals that Andrew has made it clear there would be consequences if anything was said. The investigator explains that while there's no legal requirement for an employer to disclose the identity of a witness, anonymous statements undermine the fairness to a person being investigated, as it makes it difficult to challenge the evidence. The investigator then explains to Rory that even if they were willing to anonymise his statement, if Andrew made a tribunal claim in future, Rory could be called to give evidence, as tribunals only agree to anonymous statements in exceptional circumstances. Rory thinks about it and decides he no longer wants to give a statement. The investigator proceeds on the basis of the witness statements from the customer and Martin. What if Rory decides he wants to proceed, but still on the basis he's to remain anonymous? The investigator agrees, but again explains that should the matter become subject to legal proceedings, they may be required to use Rory's name. The investigator has a meeting with Rory and takes notes. The investigator then considers what, if any, parts of Rory's statements need to be omitted or redacted to prevent identification. I'll now hand you back to Vicky, who will look at holding investigation meetings. Vicky, over to you.
Thanks, Kieran. So an investigation meeting gives the investigator a chance to speak with someone who has information about the issue under review. It is a fact-finding interview, and it's not about deciding guilt or taking disciplinary action. If formal action is needed, a separate disciplinary meeting must be arranged. Before the meeting, the investigator should plan the questions, arrange a quiet, private space and a suitable time, and send a written invitation explaining the purpose and any rights to be accompanied. During the meeting, the investigator should explain who is present, the purpose of the meeting, and that it is confidential. Ask clear, open questions to gather facts. Record answers accurately, along with any refusal to answer. Allow the interviewee to share anything else they believe is relevant, and ask if there are other people who think should be interviewed. And once the meeting is concluded, the investigator should give the interviewee a copy of their statement to review and confirm accuracy. Consider what new facts have emerged and whether more evidence or interviews are needed. Notes from the meeting will usually serve as the witness statement. You should record the date, time, attendees, key points discussed, and any refusal to answer questions. Notes don't need to be word for word and should be accurate. Audio recordings should only be made with agreement and according to company policy and in line with general data protection regulations. Covert recordings are not acceptable and may be treated as misconduct. So before we move on to the next part of the webinar, let's take a look at the role of the companion during an investigation meeting. So according to the Acas Code of Practice on Disciplinary and Grievance Procedures, workers have a legal right to be accompanied in any meeting that forms part of a grievance procedure, and any meeting or hearing that will result in or confirm a formal warning or other disciplinary action. There is no legal requirement for an employee to be accompanied during a disciplinary investigation meeting, although it is considered a good practice for employers to allow it. Typically, a companion in an investigatory meeting would be a colleague or trade union representative or official. Employers can choose to allow other types of companions. For example, an employment contract might say a partner, legal advisor, or someone from a support organisation can come. By law, employers must make reasonable adjustments for employees with a disability. This could include allowing someone else to attend, like a support worker or someone who understands the employee's disability. So we're now going to look at a case study to illustrate this, and I'll hand you back over to Kieran to do that.
Thank you, Vicky. So now let's meet Marek. Marek is Victor's son. Although there is no legal right to be accompanied at a disciplinary investigation meeting, Victor's employer has agreed to Marek as a companion. This is because English is not Victor's first language. He does not always fully understand what is being said. Marek has no experience of accompanying someone at investigation meetings, but he believes he'd be able to help his dad understand what's being asked. Victor's employer wants to ensure they're carrying out a fair investigation procedure. They explain what Marek can and cannot do during the meeting. Victor's employer wants to make sure the meeting is conducted properly and that they get all the relevant information to help them reach a decision. So although it's not a legal requirement, they allow Marek to answer questions when Victor finds it difficult to find the right words in English. Often, non-union companions have no idea what their role is and may find the situation uncomfortable. As a result, they say nothing and see their role as an observer and being there for the individual. Employers should consider giving guidance to companions on their role ahead of any meeting. But I'll hand you back over to Vicky, who'll continue the presentation. So back over to you, Vicky.
Thanks, Kieran. So we're now going to move on to the final part of the webinar, which covers what happens after the investigation is completed. Once the investigation is completed, the investigator should write a report explaining the findings and, if agreed at the beginning of the investigation, include recommendations on what should happen next. While written report is not always required, it is often helpful to have one. The investigation report should include facts that were confirmed and those that were not, how the investigation was conducted, what evidence was collected, what conclusions were reached, and what actions, if any, are recommended. The report is often shared with the decision makers and those involved in the case, so it must be professional, factual, and easy to understand. So let's now take a closer look at how the report should be structured. The report should begin with an introduction, which includes information about who authorised the investigation and who conducted it, a brief overview of the case and the purpose or terms of reference of the investigation. If the purpose of the investigation changed during the process, maybe new issues were discovered, that should be explained here too. The next section should cover process of the investigation, and in it should include describe how the investigation was done, what methods were used, what evidence was collected, who was interviewed and why, whether there was any evidence or witnesses that could not be included, along with the reasons why. Reports should also include the investigation findings. Findings can be presented by organising the evidence into 3 categories. Uncontested facts, which are things that everyone agreed on. Contested facts, this is where accounts differ or conflict. Here the investigator should assess what most likely happened based on the balance of probabilities. This means asking what is more likely than not to have occurred, and unsubstantiated claims. These are situations where no firm conclusion can be drawn because there isn't enough evidence. If further investigations would be unreasonable, the investigator should note that they could not draw a firm conclusion. The investigator should also include any mitigating factors, such as lack of intent or past good conduct, and any other relevant context to consider. If agreed at the beginning, the report should end with a conclusion that summarises the findings and suggests what, if anything, should happen next. The investigator should not recommend specific disciplinary outcomes, for example, like a dismissal, but instead recommend whether further action is needed and what form it might take. This could include formal action, for example, starting a disciplinary or grievance hearing, changing policies or procedures or further investigation into other issues uncovered. Informal action such as training or coaching, counselling, mediation between employees, or a warning that future behaviour may result in formal action. Or sometimes no further action is necessary. However, an investigator can still suggest supportive steps like counselling or mediation to help the team move forward. So once an investigation is complete, the focus shifts to deciding what happens next. The investigator's job typically ends when they hand in the report and the responsibility moves to the employer or the designated decision maker to decide the next steps. The decision maker must carefully review the findings of the investigation. Then they should decide whether the issue can be resolved informally, there's sufficient evidence to proceed with a formal disciplinary or grievance procedure, or whether the case should be closed due to lack of evidence. If there is no evidence to support further action, the case should be closed and all parties informed. However, if the investigation reveals issues that cannot be dealt with informally, formal procedures must follow as set out in the organisation's policies. It is important that the final decision on whether to proceed with a disciplinary hearing lies with someone other than the investigator. This maintains the impartiality of the process. If the decision maker's conclusion differs from the investigator's recommendations, the reason should be clearly documented as an addendum to the report. Although the investigator's main role concludes with the submission of their findings, there may be limited instances where they remain involved. For example, they may be asked to meet with the decision maker to explain aspects of their report or to attend a disciplinary hearing in a purely factual capacity. They must not express opinions or advocate for any particular outcome. In some cases, their insights might also contribute to future policy or procedural reviews, particularly if the investigation uncovered broader systemic issues. While these should not be included in the main report, they can be raised in a separate document. These observations, while unrelated to the core investigation, may still warrant follow-up and should be shared with the employer independently. There are also situations where new information comes to light during a disciplinary hearing that wasn't addressed in the initial investigation. In such cases, the hearing may need to be temporarily paused so the matter can be clarified with the investigator or investigated further. A full re-investigation is rarely necessary, but additional fact-finding may be required to ensure the process remains thorough and fair. So now let's move on to consider when records of an investigation should be retained. Records of the investigation can include a lot of information gathered about the person being investigated and their colleagues, and sometimes also customers. It can include timesheets, emails, invoices, CCTV recordings, receipts, witness statements, and much more. As an employer, you should consider why the information is being kept. There are good reasons to keep a record of an investigation. There could be subsequent legal action, for example, an employment tribunal or a breach of contract claim in a civil court, and the record could show that the employer had acted in line with the Acas Code of Practice on discipline and grievances. Where will this information be kept? The investigation records should ideally be kept by HR. They should be stored securely with access restricted to only those who need it. And how long should it be kept? In line with UK General Data Protection Regulations, the information should be kept no longer than is necessary. Once it becomes irrelevant or out of date, it should be disposed of securely. If records are being kept to defend any potential legal action, bear in mind the relevant time limits. For example, a claim of unfair dismissal should be lodged within 3 months less 1 day from the date of the employment ending, one of redundancy or equal pay within 6 months less 1 day, but a breach of contract case in the civil courts can be made within 6 years of when the breach happened. For more information on record management and security, check out the Information Commissioner's Office. So today we've been talking about investigations during disciplinary proceedings. If you would like to know more about this topic, then Acas has a number of free resource pages that you may find useful. For example, we have advice pages on investigations at work and discipline and grievance. Our free webinars run regularly, and we also make past webinar recordings available so that you can watch them at a convenient time. Our free online advice and guidance is updated regularly. We also have a regular free newsletter to help keep you up to date with new guidance, employment-related news, and scheduled training events. Acas also offers a variety of support and training options to suit your business needs and equip you with more in-depth knowledge. Our digital courses are delivered to you using Zoom and will give you the opportunity to interact with our knowledgeable trainers and explore some of the challenges you may be facing. We also offer face-to-face training at various locations around the country, and courses are available for you to book now. We have a wide range of training products to choose from. For example, if you've enjoyed today's webinar, you may also be interested in the following courses: Conducting Investigations, Managing Discipline and Grievance, and How to Conduct a Fair Hearing. We have lots of options to support you, from dealing with workplace problems to developing skills and keeping you up to date with good practice, whichever delivery method you prefer. Acas can also work with you to provide tailored support for your workplace. Our wide range of training can be delivered in-house for you, either in person or via digital platforms, and we can work with you to diagnose workplace problems and explore practical solutions. If this is something you may be interested in, call our customer services team on 0300 123 1150. So just to summarise, today we have covered when and why should you carry out an investigation, how to prepare for a disciplinary investigation, how to conduct the investigation, actions to take after the disciplinary investigation, and finally we showed you how to access further free Acas resources, find more detailed training courses, and outline some options for tailored support for your business. Thank you so much for joining us today. I'm just going to hand you back over to Kieran now.
Thanks again, Vicky. And finally, a reminder of the link to the Acas free newsletter to help keep you up to date if you've not already subscribed. Thanks for watching.